Good day, Crime Talk aficionados. My name is Scott Reisch, and this is Crime Talk. For most people that have been following our channel, as well as the legal news of the day, the jury has reached a verdict in the Derek Chauvin matter. And if you maybe noticed that we put up a video today, that was done about 11:30-ish Mountain Time. And at that point, the jury had been deliberating about 8 hours. So maybe 9 hours, a little over 9 hours of time for the jury to deliberate. Now, obviously, a jury can take as little or as much time as they need to reach a unanimous decision. 8 hours on a 3-week trial is a pretty quick verdict. I can tell you last week, my trial, it went for 4 days, and the jury deliberated about 3. It was rather quick, and it was a not guilty straight up. Although I've seen in cases where the evidence is absolutely overwhelming, very quick guilty verdicts as well. So this is, I would say, one of the worst parts for the defendants in, well, all of the parties, not just the defendant, but you have obviously the defendant, the prosecutor, the defense counsel. I've always said the second worst part of any jury deliberation is waiting for them to deliberate. The worst part is when they say they have a verdict, because it's not just everybody traipses back into the courtroom. There's things that need to be done. Usually the attorneys were told they could be within 15 minutes of the courthouse. And so they have to gather everybody. They got to gather the court reporter. They have to notify the court personnel. Particularly in a case like this, there's going to be huge security in and outside, so they got to make sure everybody's ready to go. They also have to have a deputy in the courtroom, so if there's issues, and obviously if Derek Chauvin is found guilty, more than likely his bond will be revoked, and he'll be taken into custody. So there's lots of moving parts. So when they say, oh, we need an hour to get ready, that's pretty normal. In the meantime, the jury's back there kind of sitting around waiting. And obviously we don't get to see or hear what the jury is talking about, but my experience has generally been that if a jury comes out and they're, you can hear them in the back room, as they're walking up before they come in, they're joking, they're laughing. Just my anecdotal experience, no scientific method here whatsoever. Usually that's good for the defense. If they're quiet, usually coming in, or they're waiting sometimes, because they wait in the hallway before they bring him in. But if they're in a good mood, my experience is generally that's good for the defense. If they're very somber, that usually means they're handing down a guilty verdict. And because, there's no happiness in that, they take their responsibility seriously. And in that particular case, in a case like this, the jury would know that more than likely somebody's going to prison. So, and whatever the verdict comes down here in probably about 10, 15 minutes or so, you have to respect the verdict, whether you think they got it right or you think they got it wrong. At the end of the day, you have to respect the verdict. I think both sides got a very fair trial. I think that this judge did a very good side, allowing the prosecution to try their case, present their case, to try and carry their burden of proof beyond a reasonable doubt, as well as allowing the defense, who has a constitutional right to present a defense. And, I noticed there were a lot of comments in the closing argument, even on some of the videos we talked about, where some people are like, oh, I couldn't stand the prosecution, or I couldn't stand the defense. They're just, I couldn't listen to a word they said. Oh my gosh, I can't believe that the defense said that. That wasn't supported by the evidence. In closing argument, each side can argue the evidence, reasonable inferences drawn from the evidence, or the lack thereof. So no one did anything unethical in their arguments. That's why they call it arguments. It's an argument. And ultimately, the jury instructions say that the the judges of the fact will be, in fact, the jury. The jury is going to decide who to believe. And in this particular case, no matter how the jury comes back, we are going to see, who do they believe? Did George Floyd die because of Derek Chauvin, or did George Floyd die because of a lot of other factors, and Derek Chauvin basically had to be there? So it's going to be interesting. I think the whole, it's an overstatement. Obviously, the whole world is watching, because that would be an overstatement. But I think a lot of people are watching this out of their own interest because they want to see what happens. And obviously, I think a lot of people are concerned what happens after the verdict. And hopefully nothing, right? I mean, I've said this before. You don't like something, go protest, do what you need to do. Just keep it peaceful. As soon as you start throwing things at other people, destroying other people's property, taking things without permission, that's no longer protesting. That's breaking the law, bottom line. So like I said, we will have to wait and see. And this is the thing about a court case. Literally, the only people that know what the verdict is are those jurors. The bailiff doesn't know. The court personnel don't know. The verdict should be put in a sealed envelope, and literally everyone is going to find out together. The only one who will have a little advance notice will be the judge when he reads the verdict. He has to make sure that the verdict form was signed in the correct spot. That, basically there are any boxes to check, guilty, not guilty, that is checked. Once the verdict is read, regardless whether it's guilty or not guilty, the judge will ask each side if they want the jury polled, and then the judge would go through individually, juror by juror, asking whether that is in fact their collective decision as it relates to a guilty or not guilty verdict. Usually if it's a not guilty verdict, the jury's not polled. If it's guilty, then it is, just to see, because I've only had it happen once where a juror said they had come back guilty. They polled the verdict, the jury, and they said no. And then they went back and deliberated a little further. So I don't expect that in this particular case. I thought the jury would possibly go a little longer. Like I said, there's no one thing that you can say is like, oh, they were out this long. That was a quick verdict, so it must be for the defense. Or that was really quick. It must be overwhelming because everybody knows he's guilty. It must be a guilty verdict. We don't know. And obviously we don't get to go talk to the jurors. They may be willing to talk. They may not be willing to talk. Usually a judge will release them and say that you can talk to whomever you want to. But if anybody, criticizes your decision, things like that, they have to bring it to the court's attention immediately. And obviously the court would take action. The security for the jurors is probably going to be of the utmost importance. Normally when a jury comes back, they read the verdict, they excuse the jurors. Judge will say, hey, I'm going to go talk with you back in the jury room. I'll be back in a couple minutes after he takes care of some formalities to talk to them, thank them personally for their service. I've seen some jurisdictions, they get a little piece of paper saying, thank you for your jury service, because, well, that's all that the courts have as far as resources that they can afford. And, it is a thankless job. I think one of most jurisdictions, maybe you get $50 a day for jury service. It's just simply your civic duty and obligation to do so. And the fact, that these people have taken the time out of their day, their life, their week, away from their families, their jobs, to take on this important task as a juror is a very good thing, because the system would not work without our jurors showing up and being attentive. And I have said this many, many times, and I will say it again. Jurors take their responsibilities very seriously. And here in a case like this, they know that no matter what decision they make, someone is going to be angry and upset with that verdict. It's almost like having a YouTube channel, really. No matter what you say, somebody's going to not like it. And so they have to go based upon what they, as a what's the word I'm looking for? You're going to have to trust that they made their decision based upon the evidence or the lack thereof. Okay, I have a question here. It says, Vincent, why is mistrial good for defendant, hung jury not? Neither one are good for the defendant in most cases. And obviously we're not going to have a mistrial here in this particular case because the jury's reached a decision. Hung jury. The only reason why, I don't want a mistrial or hung jury is usually, as a defense attorney and for your defendant, you have your defense, and if you have any element of surprise, so to speak, this is your opportunity. And next trial, the prosecution fixes the errors of their ways in the first trial, and I've never had something like that happen again. But that's not going to be the situation here. We obviously know that the jury has reached a verdict, and it's unanimous, and so we're just going to have to wait and see, like everybody, all at the same time, and see what, in fact, the jury has decided. Because, like I said, nobody knows at this point. Just Jimmy. Yes, shout out to Julie, Frank, and Scott, the blood-sucking lawyer. Yes, I get it. But, hey, call it the way you see it. I guess they're just Jimmy. But, the reality of it is we try to bring you everything straightforward here and call it the way we see it. But at the end of the day, let's hope everybody respects the verdict. Like I said, quick verdict. I'd say it was a rather quick verdict in regards to the length of the trial. You had a 3-week trial, and they talked for 9-10 hours. Yes, they were sequestered. I don't know what their media arrangements were as far as last night or anything along those lines, but they've been thinking about it. So yeah, it was a quick verdict in the sense of it went a long way. I thought they would at least go 3-4 days. The longer it goes, the more likely someone has real questions. But in this particular case, obviously the jury came to a resolution rather quickly. And so that is, we'll just have to wait and see whatever it is. But every side needs to respect the verdict. Now, there was a lot of talk the other day, and I didn't create this fact. This was, Congressman Waters that said basically if it wasn't the right verdict, that people needed to get more confrontational. And the judge, people were like, "Oh, Scott, I had somebody that was an inappropriate comment." Well, if you watched the video yesterday, you would see the clip from the judge where he was saying that he sure wishes that politicians would respect a co-equal branch of government and let them do their job and not interfere. Because the judge also commented that if there is an issue regarding basically not being able to be a fair trial, Maxine Waters may have put it over the top. And what does that mean? If there's a conviction, that's an issue on appeal. Bottom line. And, one of the arguments would be throughout is that there couldn't be a fair trial because of pretrial publicity. And that's the defense the argument will make on appeal if that was in fact the case. And the fact that if it was a quick verdict and it's for guilt, then the makes this argument stronger that the jurors were more concerned about the ramifications of a guilty verdict or not guilty verdict than they were with basically true justice. And guess what? Then you get to do the case all over again. So we'll see. So just Jimmy, thanks for that super chat. Always appreciate super chats. Don't ask for them, but it certainly helps highlight them here on the screen. So appreciate that. Let's see here. G-Beck, I'm about 20 minutes from Minneapolis. Nothing happened in my town when it happened. So no matter how it feels, I feel safe at home. Good. Hopefully everyone's going to feel safe. Okay. Kiwi Girl Jax, that's not quite what she said. My recollection was she said that if it wasn't a murder conviction, that they needed to get more, the protesters needed to get more confrontational. That's the one that got everybody's attention. So yeah, we'll see. Oh, that's good. It disappeared. I like this comment. Where'd it go? It was like blocked or something. I don't know. It was like faded. Okay, Karen. Hey, Scott, when I first started watching, you thought you were a bit of a pompous ass. Laugh out loud. Now I don't watch any other crime news channel but yours. Thanks, Karen. We appreciate that. And, you're not the first person that would have thought I could be a pompous ass. I try not to be. I try to generally live by the general principle that there are two types of people in the world, those that are humble and those that are about to be. So I try not to let my ego get too large for sure. Kaylee, I wonder if the jury could hear the aggression and unrest outside the courthouse. Obviously, I wasn't there. I hadn't watched any news channels, but I knew there were protesters out there, but I don't know if they were kept far enough away where the jury was deliberating that they could or could not hear that. You've got to respect the verdict. Absolutely. You got to respect the process. I was having a conversation with a member of the judiciary the other day and a non-lawyer judge. And, it was very similar along the lines of you have to trust the process. If you think that something wasn't fair at the lower level, you go up on appeal. Our judicial system is anything but perfect, but it's still pretty darn good. But if you don't like the result, there's a process. You don't go out and you don't destroy things, break things, burn things. You have to respect the process. Let's see here. Justice will be served. I mourn for Chauvin, only his bad judgment. I've got the gift of goodbye. Do you have to donate dollars to get a shout out? No. The gift of goodbye. How's that for you? Okay. Like I said, we don't ask people to, there's some shows I've seen actually kind of beg for super chats. We don't do that, but it does help when things are going by really quick. They pop up on my screen here so I can actually see them, but not necessary. Is it working, Frank?
Yeah, I think to me here, today's still working on that.
Okay, but nothing, nothing on the screen yet.
Okay.
All right. Yeah. Julie, now for the Vallow Day Bell. The Lori Vallow Chad Day Bell case, that'll be probably after the first of the year is my thinking, the way things are going. Yeah. All right. So they should be back here literally momentarily as it relates to that. All right, Betty C. I don't chat much here, but always enjoy watching your show. Very informative. Thank you. Appreciate each and every one of you. We have a little thing here where our numbers were just climbing. And all of a sudden our subscribers just started going slowed to a trickle. And it looks like, we may be being shadow banned or something. But that's the way it is. If somebody doesn't like the opinion or what you talk about, they literally can complain and do it. It's kind of frustrating. Let's see. Crazy Cat Lay. Scott, love Crime Talk, follow you on social media channels. Thanks for making COVID fun. Well, I'm glad to help. Hopefully we've all been able to get through the whole COVID thing here, regardless of where you are. Hopefully things are getting back to normal in somewhat. I mean, it's kind of getting slowly back to normal here. We're actually starting jury trials again. Most places are resuming jury trials again, but just at a reduced basis, which is going to be very interesting when it comes to speedy trial rights. We've talked about that before, not the place here, but we'll see. There's so many different, opinions in the chats, not only on today's chat, but for other chats where people have obviously made their mind up. I tried to go into the Chauvin matter. Obviously, we've seen it. We've talked about it. I still think the one thing that I pointed out early on was that one picture where Chauvin has Mr. Floyd on the ground, and he almost looks like he's enjoying it just a little too much. And I said that when that first video came out, and there was some talk about body language at one point in the defense case, and then the prosecution got up and said, yeah, let's take a look at this picture, which is that picture that I was just referring to. And says, yeah, what does that say for body language? And, that's one of those things where, the prosecution, could have played that, put that picture up every 10 seconds or so, and it would have been the best thing for them. And I've said this before, and I'll say it again, regardless of what happens, there were some great attorneys on both sides. A lot of the attorneys for the prosecutors literally came out of private practice to prosecute this case, which is very, very unusual. But the Attorney General's office had to prosecute it because of the fact that the district attorney, where the case was charged there in Minneapolis, it was basically recused. There were people that didn't think that a fair investigation was going to be done, and therefore the Attorney General's office picked it up. And on the defense side, whether I know some people don't like him. Oh, I couldn't stand him. I get it. But if you get, and that's going to happen on any case, there's going to be jurors that love you. There are going to be jurors that hate the attorney. It's just reality of life. You cannot have everybody like you. But the point is, it's not a popularity contest. Who was slicker? Who was more articulate on the stand? I mean, at the podium. It comes down to who was able to get their message across. And here, the prosecution took 35 witnesses to say the only thing that killed George Floyd was asphyxia, and Derek Chauvin was the only one responsible. And the defense said, hey, look at the results. They're saying it wasn't asphyxia. It was a heart attack. And so that question then becomes, was that reasonable doubt for the jurors? Or did they say, to Mr. Nelson, not buying what you're selling? Or did they say, the prosecution, we're not buying what you're selling? You can't ignore the fact that this guy had drugs in his system. Was it the perfect storm? Or was it only because of Derek Chauvin? So, like I said, the jury is the judge of facts, right? And this is a classic case of a question of fact. It's not a question of law whether Derek Chauvin committed him. Yes, they find that fact, and it's based upon the law. But this is like if you have a simple car accident case, right? The judge tries the case. They're judge of the law. The jury is the judge of the facts. Each party says, I had the green light, and there was an accident. The jury decides who had the green light. Just like in this particular case, here we have a situation where the prosecution is saying George Floyd died of asphyxia. The defense is saying, no, George Floyd died of a heart attack, and all related to other factors, which is why the coroner put all these other issues in their autopsy report. So yeah, it's going to be interesting. Jackie, little super chat there. Thank you. Thanks for the live streaming. And just Jimmy also. I see you, James Moen, my brother. All right. And, this is what, and I don't know, maybe we can have a show of hands here. Who here has ever watched a case online from beginning to end? If maybe you've never served on a jury, show of hands. In this particular case, like I said, regardless of whatever side wins, you got to see some really good lawyering. You got to see some really fine expert witnesses. You got to see a very, very good judge, if not a great judge, maintain these proceedings, kept these proceedings moving along, but yet he treated everyone in the courtroom with dignity and respect. And if you noticed, the counsel had a lot of respect for the judge too. When he ruled, he ruled. There was no arguing, going back to the judge. He had made up his mind, and that was it. So, and he was the one, the judge, Judge Cahill was the one that said, hey, we can't allow people in the courtroom, but this case is significant enough. I'm going to allow the live streaming of it, which I think was absolutely great. A case like this where there's so many emotions for both sides. There's so many people that are invested emotionally, politically, for whatever reason. If you how the case turns out, you can go back and watch the whole thing, and you can't try to spin it. Nobody can say this is what it is. You got to see everything. You didn't just get the spin of some guy in the evening news that has 30 seconds to tell you the highlight of the day. Well, there were lots of highlights throughout the day that obviously would never make it in a news report. Little nuances about witnesses, how they agreed with the defense on cross-examination. Obviously, when it was Dr. Tobin, I believe. Is it Tobin? The pulmonologist. He was a very effective witness, in my humble opinion. And he, it was a bad day for the defense. It really was. And then, the defense had a better day. There's no, I've been in cases where they just pile it on. You're just like, God, get me out of here. I have no good facts. Can I buy a good fact for 100, please? And it's not coming, and you just sit there and you take it and you get beat up. And, but it's, for the most part, it's like a good tennis match. It's a back and forth, and every now and then somebody hits an ace, but just because you have an ace one day doesn't mean you're not going to win the game or the match. Pat, super chat here. I would hate to be judged by the emotional reaction of the public. Facts in their totality matter, or it is no longer justice. Can't disagree with you there, Pat. I mean, and that's why, like I said, we don't decide cases. I mean, think about it. This matter, this incident on the street took roughly 20 minutes, and Derek Chauvin was on George Floyd for 9 minutes and 29 seconds of that video. But it took 3 weeks to really explain what was going on, what happened. And, obviously we'll all find out together, but the strongest argument for the defense is, hey, the experts can't agree. How can you? That's reasonable doubt. So we will have to wait and see for sure. Random, thanks to all the mods. Yes. Thank you, all the mods. Appreciate all that you do. I know you got some tough decisions to make out there, and try to keep everybody happy, which is always impossible. But we try to, keep it unless it's just absolutely going to violate something that YouTube is going to get us in trouble for. We try to keep it up. Bethany, I love this channel so much. Thank you for teaching me more about the realities of the courtroom. Yeah. And I can tell you, if I was the counsel there, I'd be like, let's get these people in one way or the other. Let's wrap this up. Let's see here. Sherry Long. Scott, thank you for all your hard work and covering the trial, professional insights and explanations. Well, thanks. That's why we started this channel way back about two and a half years ago, because we were just frustrated by the news media coverage. And what's the best way to, have somebody that actually knows what they're doing, talking about it, and not speculating about things. I mean, we could sit and speculate, gee, I wonder what they came back. Was it all guilty on all three, guilty on 1, 2, 3, not guilty? We just don't know. And until it comes out, we could speculate all day long, but it's not anything based upon what we know. And remember, there's a difference between belief and knowledge. And so we'll have to see what goes on here. And he does not get mic drop. Oops, I'm an innocent verdict, and you all see riot. Or let's see. Oh yeah, somebody, Kathleen, because the law says a jury of our peers, had somebody that made a comment said we should have professional jurors. I don't like that idea. I like the idea of jurors of our peers. I frankly think if it was up to me, I would have instead of legislators, members of Congress, basically your number gets picked and they can send you off. I think you can do just as good a job as most people. And we actually have people that have reason and common sense making decisions. You're going to come usually to a much better decision than people that have already made up their mind before the issue and they won't actually keep an open mind. I've got the gift of goodbye. You're the best. Thanks for hanging out with us. Of course. Thank you. What is the max penalty time he's facing? On the one count, it's up to 40 years, but the prosecution had filed for some aggravating factors, so it could be 4 if there was a guilty verdict. And a lot of people cut out yesterday after the jury got their charge. But there was a very interesting hearing that obviously wasn't in the presence of the jury. A lot of people didn't see. One, that was where the judge made his comments regarding Representative Maxine Waters and her comments and saying that may be enough if there's a conviction for a new trial. And when the judge is telling you that, politicians, keep your mouth shut. Don't comment on things you don't know anything about. But there was also a discussion, what they call a Blakely hearing. And there's a case, I think it's Blakely, no, it's Crawford v. I think it's just People v. Blakely. But basically anything that is an enhancer, all right? Let's say you commit an assault by way of example, and you just happen to have a gun. A gun would be an enhancer. If there's anything that's going to increase your penalty range, a jury, it has to be charged, presented to the jury, proven beyond a reasonable doubt. Here, the sentencing aggravating factors, Derek Chauvin did what they call a Blakely waiver. And he said, Judge, I understand if there's a conviction that these factors that need to be considered, I want the court to consider them, not the jury. And so that's a Blakely waiver, all right? So if there's a presumptive range of, say, a sentence of 2 to 6 years, and you say, hey, for plea negotiations, I'll take a greater range. Actually, we saw this, for example, in the Nurse Kenny case here in Colorado regarding the death of Kelsey Barrett. She pled guilty to a Class 6 felony. The presumptive range was 12 to 18 months. She waived Blakely so that she could be sentenced all the way up to 3 years. The judge didn't engage in the appropriate colloquy. The Court of Appeals said, you didn't do it right, Judge. Therefore, you can only sentence her in the 12 to 18 month range. So that was an interesting conversation that took place yesterday outside the presence of the jury after basically a lot of people dropped off from watching, which I get. It's not very interesting. People have busy lives to do, things to do, kids to take care of, jobs to tend to, etc. And frankly, if you're not familiar with the issue, it may not make a whole lot of sense. But yeah, that's what went on there. So the one count carries up to 40 years. Tanya Bixby, how's it going? It's going well. Just waiting here for the jury to come out with its decision. And obviously they should have had time now to have made their get everybody in the courtroom. You know, like I said early on, a lot of people think that, you know, everybody's just waiting outside the courtroom. They're not. They're close. And I assure you, from the attorneys involved, you're there. You're waiting. And you're useless. And even when my offices used to be really close downtown, I would never go back to the office. I would stay close by because what if something happened? You have to be within 15 minutes. And every time I've ever taken a walk or something, I usually get a call. We have a question. Come back. That was but it's a terrible time for the attorneys as well, because you're always second guessing yourself, wondering, wow, did I lose him? I can't tell. And it's even more difficult with masks. I can tell you on this case that we did just last week, there was a juror in the courtroom. Obviously, there was a juror, and I thought we had lost this particular juror. She was, sitting there with her arms crossed, wasn't taking notes, wasn't attentive in any way. I'm like, oh man, she's made up her mind. It's going to be guilty. That's just the way it is. You know, lost one. Best we can do is maybe a hung jury. And obviously, when it came back not guilty for all counts, that was a good thing. So obviously, she had shut down, but in our favor. And that's the thing. You know, jurors don't relay what they're thinking most of the time. Sometimes you can get an idea, but with masks these days, you know, unless they're rolling their eyes and you see it, it's very hard and unlikely to see what they're thinking. So, you know, and of course, everybody has a lot of responsibility. The prosecution has responsibility bringing this case on behalf of the people of the state of Minnesota. The defense, obviously, you know, gee, if I messed something up, did I not answer the right question? Did I not ask it correctly? Was that the one question that got my client convicted? That's tough. And a lot of people think, oh, it's really easy to go be a lawyer. Yeah, I guess it really is. The question is, can you stomach the pressure that comes with it? Valerie, is it just one charge or they can rule on all charges? Good question. So the judge went through and explained in the jury instructions that you could find basically him guilty of all of the charges, none of them, or some of them. And then the court would have to decide at sentencing if there was something called merger. So basically where they're the same elements but like lesser includeds, and then the judge would decide the appropriate sentencing range. So they could find him guilty of all charges, some of them, or none of them at all. And then, like I said, the judge would have to decide at sentencing if there was a guilty verdict as to what is the appropriate sentence for sure. Michelle Gerber, what's the next trial you're putting up on the page? I'm not sure. We've been pretty focused on this one. And to be honest with you, not necessarily for me, but for Frank, it's a lot of work to keep those up and going. So, I wish we could do them every day, but it just depends on which ones we can find and have access to, because some of them there's issues where we can't live stream them. But for example, this one came from the court, so we can actually do that. So Valerie, hope that answers your question as well. Scott, any have been televised? Would love to watch you. Actually, I had a case that was televised years and years ago, but it's on one of our videos way back, and it was a child abuse resulting in death case, and the ABC had a show called In the Jury Room, and they followed both the prosecution and the defense in preparation. They received special permission from our Colorado Supreme Court to allow the videotaping of the jury deliberations, which was very, very interesting. I can't think of the video off the top of my head, but it's down there. It was probably one of the more early videos that we put up, and we'll see. So yeah. And here's the thing, a lot of people are saying, oh, he's guilty of this, he's guilty of that. I just don't know. I really don't, because my trial last week, I was thinking, oh no, that was so fast. It's got to be a guilty verdict. I mean, I just didn't know. We didn't know. We were trying our case. We didn't have any feelings. It was a hard-fought case, and they came back not guilty. They could have easily said guilty. I'd be like, okay, I can see how it happened. In this particular case, I just don't know. I don't want to guess because I probably would be wrong. Bottom line, I just don't know. I just do not know. And nobody knows. And that's the beautiful thing about our, jury system is that nobody does, in fact, know. For Frank and his mic drop, my stream was 99% flawless. Good on you. Just Jimmy, thank you. Frank appreciates that. I assure you, everybody here, the little Crime Talk crew does everything. Julie, Frank, they all try to do a great job. So we appreciate you all. We really do. If you all weren't here, we wouldn't be here, and we appreciate it. And that's why we try to put out a good product every day. I hope you like it. If you haven't done so, please subscribe, hit that like button as well if you haven't done so. And then also remember, tonight is our live show. I wonder if we'll have anything to talk about. Yeah. Maybe a trial or a verdict's coming back yet. We'll just have to wait and see. Let's see. Releasing the settlement ahead of the defense color of the jury. Yeah, you just don't know. I mean, there's so many things that, the jury, the jury instructions, and those are pretty routine jury instructions that the court read, is that the jurors need to make their decision based upon neither passion nor prejudice, simply based upon the law and the facts, and let the chips fall where they may. And so, we'll see. And, eventually some jurors will talk to the public and say that if they were swayed. I don't think they'll ever say that they were swayed by public concern. I think they'll say one way or the other the evidence was either there or, overwhelming and we convicted, or it wasn't there and we said not guilty. We'll just have to wait and see. Shadow wants to know, do you think the media coverage helps or hurts the court system? I think it helps. I think it helps that people can click on and see what's going on in the courtroom, and people can see our justice system in progress. Because yes, it is an open courtroom, and before COVID, everybody could just come in and sit down and watch. And but I think that it helps instill trust and confidence in the system. And the beautiful thing about this case is there's going to be somebody on some side upset, and they can't say, well, I didn't see that, or I didn't know about that. Go watch the entire live stream. Heck, come to Crime Talk and you can watch the entire live stream of the jury selection and the entire court process. We've got it all covered. It's there on video so you can watch it. And I think it helps for people to understand the system and to make sure it's working. All right. And when you have a good judge like we had in this particular case, I think it helps even more. If juries were totally anonymous, this is a question from Pat. If juries were totally anonymous to the public before, during, and after, do you think this would help keep them honest? For the most part, jurors' identities and names and locations, they are in fact kept anonymous, and I think it works. I've had cases where jurors have asked to, particularly like any gang case where there's been some, violent stuff. They wanted to have escorts to the car. I get it. I once had a jury question where the question was, does the defendant have access to our home addresses? Ooh, not a good question, right? So yeah, I think the jurors, if they have any concerns, they'll let somebody know. But I've never been made aware of, nor can I even think of a specific instance. I'm sure there's something where jurors were somehow retaliated against in some particular way. Now, I did see a report that the expert for the defense the other day, his old address, somebody put pig's blood on the front doorstep. Like, really, people? Really? The man, he's testifying to his opinion. He's subject to cross-examination. The jurors are going to decide whether they believe it or not. You don't need to go around trying to intimidate people in any respect. Researcher Susie, researcher Susie. How is Miss Winnie? Miss Winnie's doing great. She is keeping the lovely Miss Kristen busy and occupied, no doubt. But she has a plethora of toys to choose from that usually make a lot of noise to keep her happy. So we can see. All right, so we thought we would have the verdict by now in the Chauvin matter, but yeah, there it is. We're still waiting. The judge has not come out yet. Normally it always takes longer than you think it will, trying to get everybody together. And I am sure that there is some delay in coordinating. They've got the National Guard. They have the police. Everybody is out there. They're trying to make sure everybody's in place. So if there is going to be any protest or violence, and let's hope there's not. I mean, there can be protests, just no violence or destruction. Then we can, I'm sure somebody from the city probably asked the judge, hold up, give us a few more minutes. We weren't expecting it this quickly. Let's see here. Good question. Jim Jules. I saw, and it's GYM, Jules, Jules. I saw that they had 14 jurors, 2 for backups. Those are known as alternate jurors. Do all 14 take part in the verdict? Good question. No. So the 14 jurors were selected, and obviously they heard all of the evidence. Let's say, for example, though, that let's say a juror got sick, couldn't participate. They would then bring the alternate back in and say, you're the alternate, you haven't been excused, you need to deliberate. And then the jury would have to basically start their deliberations all over again if an alternate had to take the spot of a juror. In this particular case, I mean, it wasn't that long. They didn't lose any jurors throughout this process whatsoever. There was a comment by the judge yesterday, and you didn't hear much about this, but apparently somebody had sent some communication. Oh, here we go. Where the judge is coming on, and we're going to find out the verdict in the people of the state of Minnesota versus Derek Chauvin trial. I think we heard the judge coming in. But while we're waiting for him, obviously this trial went on for some 3 weeks. The jury delivered about 8 hours. So let's see what the judge has to say. This is Judge Cahill.
All right, for the jury.
Yeah, I can hear.
All right, please be seated. Members of the jury, I understand you have a verdict. Members of the jury, I will now read the verdicts as they will appear in the permanent records of the 4th Judicial District. State of Minnesota, County of Hennepin, District Court, 4th Judicial District. State of Minnesota Plaintiff versus Derek Michael Chauvin, Defendant. Verdict, Count 1. Court file number 27, CR 20-12646. We, the jury, in the above entitled matter as to Count 1, unintentional second-degree murder while committing a felony, find the defendant guilty. This verdict agreed to this 20th day of April 2021 at 1:44 p.m. Signed, juror foreperson, juror number 19. Same caption, verdict count 2. We, the jury, in the above entitled matter as to count 2, third-degree murder, perpetrating an eminently dangerous act, find the defendant guilty. This verdict agreed to this 20th day of April 2021 at 1:45 p.m. Signed by jury foreperson, juror number 19. Same caption, verdict count 3. We, the jury, in the above entitled matter as to count 3, second-degree manslaughter, culpable negligence, creating an unreasonable risk, find the defendant guilty. This verdict agreed to this 20th day of April 2021 at 1:45 p.m.
There you go.
Jury foreperson 019. Members of the jury, I'm now going to ask you individually if these are your true and correct verdicts.
All right,
Please
there it is.
respond yes or no. Juror number 2, are these your true and correct verdicts?
Court is polling the
Juror number 9, are these your true and correct verdicts?
Reached unanimous verdicts.
Juror
Guilty
number
on all
19,
three
are these your
counts,
true and
second,
correct
third,
verdicts?
and second-degree manslaughter.
Juror number 27, are these your true and correct verdicts?
Yes.
Juror number 44, are these your true and correct verdicts?
Yes.
Juror number 52, are these your true and correct verdicts?
Yes.
Juror number 55, are these your true and correct verdicts?
Yes.
Juror number 79, are these your true and correct verdicts?
Yes.
Juror number 85, are these your true and correct verdicts?
Yes.
Juror number 89, are these your true and correct verdicts?
Yes.
Juror number 91, are these your true and correct verdicts?
Yes.
Juror number 92, are these your true and correct verdicts?
Yes.
Are these your verdicts, so say you one, so say you all?
Yes.
Members of the jury, I find that the verdicts as read reflect the will of the jury and will be filed accordingly. I have to thank you on behalf of the people of the state of Minnesota for not only jury service, but heavy-duty jury service. What I'm going to ask you to do now is to follow the deputy back into your usual room, and I will join you in a few minutes to answer questions and to advise you further. So, all rise for the jury.
All right. So we'll keep the screen up here, but the jury's exiting the courtroom, and they're going to get a sentencing date. More than likely, the bond will be revoked,
All right.
and Chauvin will be taken into custody here in just a.
With the guilty verdicts returned, we're going to have Blakely. You may file a written argument as to Blakely factors within 1 week. The court will issue findings on the Blakely factors, the factual findings, 1 week after that. We'll order a PSI immediately, returnable in 4 weeks. And we will also have a briefing on, after you get the PSI, 6 weeks from now, and then 8 weeks from now, we will have sentencing. We'll get you the exact dates in a scheduling order. Is there a motion on behalf of the state?
Your Honor, the state would move to have the court revoke the defendant's bail and remand him into custody pending sentencing.
Bail is revoked, bond is discharged, and the defendant is remanded to the custody of the Hennepin County Sheriff. Anything further?
All
right. Thank you.
All right. As you can see there, Derek Chauvin now being placed in handcuffs after the jury returned a verdict of guilty to all counts. To guilty to second-degree murder, guilty to third-degree murder, and guilty of second-degree manslaughter. So, I know some people didn't like Mr. Nelson, but I think he did a great job with what he had to work with in this particular case. But the reality of it is the jury wasn't buying what the defense was selling, and they were absolutely convinced that Derek Chauvin was absolutely solely responsible for the death of George Floyd. And so, justice has been meted out, and hopefully people will respect the verdict. The reality of it is that as the court laid it out and what will take place, obviously the bond was revoked, not surprisingly, and the judge ordered that within 1 week that the briefing should be done as it relates to the aggravating sentencing circumstances that the judge will be the finder of fact on in that particular case because of what they refer to as a Blakely waiver. The pre-sentence investigation report will be done within 4 weeks. Any objections will be due in 6 weeks, and sentencing will be done in roughly 8 weeks. So that will be, as you can see, I mean, that judge doesn't mess around. He set the orders, he sets the dates, and I guarantee you everyone's going to follow and meet their deadlines. As you saw, Derek Chauvin looked over at his counsel, particularly when he said he was going to have his bond revoked. I'm sure that that really came as no surprise, other than, he didn't want to go into custody. Maybe he was hoping he'd have a little time. Nope. Cases like this, if you lose, you go into custody immediately, and then you'll just have to wait and see what happens at sentencing. In this particular case, Derek Chauvin is going to prison. I believe the second-degree murder carries up to 40 years, and now the court will decide, what the appropriate sentence will be. A good choice by the defense, not having the jury find aggravating factors. Maybe he'll get some love from the judge, but you never know in this particular case. So yeah, roughly 8 weeks from now, we'll have a sentencing. So April, May, sometime late June, early July. And we'll let you know when that will be, and hopefully it will be covered as well. And question here, Stacey, how will this impact the other officers? Well, obviously, I'm sure the other officers were rather attentive to this particular case, and we're certainly hoping for a not guilty verdict. But although they were never, except at one point where they were all, I think, on Mr. Floyd, standing around doing other things, they can be found guilty of everything that Derek Chauvin was found guilty of under a theory of complicity. If you aid, encourage, abet, you assist somebody in the commission of an offense, basically you knew or should have known in this particular case, then they can all be found guilty of the same charges. I think some of them are not charged with the second degree, but I think third and then the second degree manslaughter. Those trials are all set where they'll be tried the same. But the other thing for the other officers is now they can point to the finger and say the guilty guy was Derek Chauvin, and everybody's going to know that he was found guilty. And I was standing there, but I'm just, I think the one guy had been on the job, 2 weeks or something. So, he, that may be their argument. So we'll have to see. A couple other questions. Do you think he'll get a bond on appeal? Probably not. Probably not. Rarely, like I said, I don't know exactly how they would do it in Minnesota, but generally the rule is, nope, you've been convicted, you get to go to prison unless somebody thinks there's some great issue on appeal that is so you have a very high probability of success on appeal. So that's where that stands. So no, I don't think he'll get an appeal bond in this particular case. So yeah, obviously a very good day for the prosecution. They won all 3 counts, and the defense guilty on all counts. I've said this from the beginning. I think both sides were very professional, very good, and I think that for appellate and post-conviction relief issues, Mr. Nelson provided Derek Chauvin with an excellent defense, which is good. That means if it goes up on appeal, they can't say that he had ineffective counsel. This is a good thing. That means that justice works that way, and a jury in this particular case heard the facts and concluded that Derek Chauvin was in fact guilty. And so we'll just have to see what the ultimate sentence will be. And this judge will be handling the case of all of the other officers as well. And so hopefully that, I'm sure he'll give everyone a fair trial. I'm sorry, I was looking at some of the comments here. And, people can say, oh, the jurors were scared, whatever. If there was somebody that I just don't see that. The jury made their decision. And they made their decision. I think jurors take their jobs very seriously, and I'm not going to second guess what the jury did. But at the end of the day, and somebody's asking to repeat the charges, Derek Chauvin was found guilty of second-degree murder, third-degree murder, as well as second-degree manslaughter. And the court will have to decide what merges, whether some are a lesser included offense, so there'd be a merger, or whether they're separate elements so that they can be considered separate offenses, even though it's the same conduct. All those sentences would basically merge or be run concurrent. Someone asked a question, Jamie85, the Lion, will the same jury oversee the other officer's case? Nope. It'll be an all brand new jury of 12 jurors plus usually 2 alternates. And, who knows? There may not be any other jury trials because who knows? The other officers could be offered plea bargains. They may want to take them. It just really depends on how they want to handle this. Certainly, one could certainly argue that the other officers were not as culpable as they were not the one. They're basically completely disregarding George Floyd's medical situation and basically strangling him, asphyxiating him. So yeah, it's one could argue that they're less culpable, but under the law they could be held culpable like they had their knee on George Floyd's neck. Mike, so how many years can he get? Like I said, I believe second degree off the top of my head was 40 years. The third degree I think is 20, and the manslaughter is 10. Donna, Scott, I hope you put all the trial in video together all the way through. I'd gladly buy it. Donna, it's already on our website. It's on our YouTube page. You can watch it for free. And I think most of them are monetized except for just a couple days. So you don't even have to buy anything. How's that for a bonus? Because we brought it to you live. Let's see. Question. Will the mistrial issue come back or can it? It'll be an issue that'll be raised on appeal. So if the anything that the defense objected to, because you have to object for it to be preserved for appeal. So anything that was objected to, there was a motion filed, any ruling that the court made that the defense thinks is wrong becomes an appellate issue. Now, the appellate attorneys usually pick their best issues. They don't just throw every time somebody objected out there. It has to be a substantive issue for sure. So that'll go up on appeal, and then the appellate court will decide whether it resulted in an unfair trial. Obviously, one of the issues is going to be pretrial publicity in this case, publicity in the case, remarks made by people. Those are all things that the appellate courts will decide and say, hey, this can't be a fair trial. Although there's been nothing to date that would indicate that the jurors were influenced by these in any other way, so you can't really say that it's not going to be a huge issue. Appellate courts don't like to reverse cases unless a serious mistake was made. So we'll have to wait and see. Question: how can people not see the jury as they come in and go in the morning and at night? Could someone have intimidated the jury? I mean, I guess it's possible as jurors come and go. Maybe they see crowds, people, protesting, what have you. But if a juror believes that he or she were threatened in any way or intimidated or didn't think that they could do their job, they have a duty to tell the court. And in this particular case, the court would make sure that didn't happen. I'm sure precautions were taken. I'm sure they were briefed. They all knew, as the judge described it, as this was super duty jury service. And, that's the way it is. The jury has spoken, and now you have to respect the decision. All right. See if there's any other questions here. Charleston, the video convicted him. It's not going away. I agree. That was clearly not good for the defense, obviously. But the beautiful thing is, hey, regardless of our flaws, we were able to watch the jury system at work. We got to see all the entire evidence. And if anybody has any questions or what have you about the case, they can go back and watch the whole thing. They don't have to take the word of some reporter that was in and out of the courtroom all day long. So that's it. So then the question then becomes, what do they do with Mr. Chauvin? So obviously he was remanded. He'll be more than likely held at the county jail because his bond was in fact revoked. Unlikely that he'll get an appeal bond, which would be after sentencing. Sentencing will be in about 8 weeks. During that time, the court has, and they literally work for the court, it's what they call the probation department. Now, not everybody gets probation, but that's what they call them. And somebody from the probation department will prepare a pre-sentence investigation report, which will provide information to the court regarding the background of Derek Chauvin, his educational history, his family life, personal information about, married. I think he's divorced now. Financial obligations that he may have outstanding, anything along those lines that will provide information to the court so that the court can use that in tailoring the appropriate sentence, right? If somebody has a drug issue, you want to make sure you try to get them drug treatment as a condition of whether it's probation or prison, something along those lines. In this particular case, what do you do other than send somebody to jail for prison because you're punishing them for their conduct? It's not like you're going to rehabilitate them in any way. And then at sentencing, what does the defense say? Well, if he was my client, I'd tell him not to say a word because anything you say can be used against you, and you don't want to do anything that's going to taint any of the appellate issues in the future. And that's not going to offend the court. The defendant always gets the right to speak last at the sentencing hearing. It's called the statement in allocution. So, that'll take place. Once he is in fact sentenced, Derek Chauvin is actually sentenced, then he'll be sent off to the state prison system, the Department of Corrections, where they usually have some sort of diagnostic center where they say, hey, where can we put this guy to put it safely? Do we transfer him out of state? Can we keep him here in the state? Because remember, the state now has a duty to keep him safe. Isn't that ironic? And so they have to do everything they can to make sure that he's safe, and he goes off to prison. And at that time, their time computation people will calculate, say, okay, hey, you have this sentence. This is when you're eligible for parole. This is when we absolutely have to release you. But the reality of it is, Derek Chauvin's more than likely going to go spend the next several decades in prison. If I was a betting man about that, And what can they say about his conduct throughout the trial? He wasn't disruptive. We've all seen cases where people were disruptive. Chauvin was sitting over there taking notes. Obviously, they're probably sitting there wondering, wow, should I have testified or not testified? I don't think it would have made a single iota of difference whether Derek Chauvin had testified or not in this particular case. I think it was a fait accompli when the jury went back, and it wasn't going to matter what took place. Let's see here. What about the evidence that proved the way they handled the suspects was how they were trained? So they should indict whomever approved the training. Well, good point, Richard. There was stuff brought out, and witnesses testified that he was doing what was in accordance with his training, although it's always a changing set of circumstances. Now, the city basically acknowledged that their training program sucked, which is one of the reasons why they paid the George Floyd family some $27 million, because basically they wanted changes in the training program as well. And the city basically said, we failed everybody, not only Mr. Floyd, but Derek Chauvin by that. But the jury has spoken. There was various questions of fact for the jury to decide. Was Chauvin acting in accordance with his training or not? The jury decided he was not. And that's a question of fact, so that question is over. No further issue that on appeal in any way whatsoever. That has been decided. The only thing that goes up on appeal was there legal errors that were made that resulted in an unfair trial. And not just because, a question was answered or the answer was introduced into evidence, but it was be so substantial that it resulted in an unfair trial. And lots of courts come down with rulings that say, although there was error, it was harmless in light of the overwhelming evidence in this particular case. And with no evidence that the jury was intimidated, a high-profile case doesn't necessarily mean that is in fact a basis for that. So yeah, accidental fire. How would you spend your cut of $27 million? PC-12? That'd be a Pilatus airplane 12. I don't know, $27 million. I maybe go with a Citation jet. Just saying, but I didn't get that. And, hey, the attorneys for the Floyd family were able to negotiate $27 million. I wish that they had waited until after the verdict to announce that, but politicians get in the way of justice sometime or try to influence it. Let's see here. $1 million bond paid for him to be free till now. What a waste of money. Well, they didn't pay the whole $1 million bond. It's just that if he didn't show up for court, they would have to pay that bond. It had to be secured by property normally. I think his parents posted that bond. But yeah, that's what happens when you're convicted of various crimes in lots of jurisdictions. Bond is revoked. I once had a judge, I swear to God, she was a terrible judge. She's since retired, but it was a simple little drug case. And we were going to trial on this drug case because the client had immigration issues. If he lost, he was going to prison. We went to trial and we lost. The judge revoked his bond. He was not a flight risk. In fact, he wanted to stay in the United States. That was the whole point. And the judge revoked his bond. Couldn't believe it. She'd never done criminal, and so she was told, she said later that, well, I thought I was supposed to do that in every case. No, Judge, no. Scott, do you think he'll be on suicide watch? Zed, normally when people go into custody, if they have any inclinations that they're going to hurt themselves, they'll put them on suicide watch. But I don't know. I mean, Chauvin's kind of, he didn't get up and do it and maintain, but he's obviously his defense was that he did nothing wrong and that he was simply just doing his job. So, yeah, that's where that stands. You sound sad. I don't sound sad. I mean, the verdict is in. I thought that he would probably be convicted of something. I was thinking more along the lines of the second-degree manslaughter, not all charges, but that's for the jury to decide, and I respect their verdict. Not tired at all. The jury has spoken. So I have no problem with the verdict. I mean, I said this all along, that if you watch this trial from beginning to end, if you wanted to convict Derek Chauvin, you could convict him based upon the evidence. If you thought that there was reasonable doubt, there was something that you could hang your hat on to say that there was reasonable doubt in the verdict. And that's where that stands. Real quick here. Let's see here. So that, I mean, yeah, certainly not sad. That's just the way it stands. So someone wants to know what the charges were. The murder in the second degree carries a sentence of not more than 40 years in prison, and it's basically caused the death of a human being with the intent to effect the death of that person or another, but without premeditation. Pretty much standard second degree murder. The Minnesota third degree murder, that particular statute carries 25 years as a maximum penalty, where whomever without the intent to cause death proximately caused the death of a human being, directly or indirectly. Like I said, it's up to 25 years in prison, $40,000 fine, or both. And judges usually don't impose fines because nobody has any money by the time they get done with the criminal justice system, unless it's like a white-collar crime case. And the manslaughter charge carries, I believe, up to 10 years on that one. Yep, 10 years, not more than a fine of $20,000 or both. And that's by culpable negligence, where the person creates an unreasonable risk and consciously takes a chance of causing death or great bodily harm to another person. So that's where those are the charges. The jury found Derek Chauvin guilty of all counts, and the judge will have to decide whether it fits into the extreme aggravation, which basically could be even higher. We'll know in about 8 weeks in regards to that. Let's see here. So what happened? Question: what happened to the other officers who were scheduled to be in trial? Their trials, I believe, commence in a couple of weeks, and it'll be the same judge. Not sure it'll be the same prosecutorial team, but it'll certainly do that. Pat, Will Nelson appeal. Yes, it's automatic. Basically, when somebody is convicted of a crime, crimes such of this nature, they go to prison. You're going to appeal, even if you think there are no issues. There are issues in this particular case, and we've said this before. The reason why the appellate courts are important in cases is that when you're at the trial court level, there's a lot of emotion, right? You got protesters outside. You got the family that's in the courtroom. The jury sees it. There's a lot of things, going on that affect how the courts will rule on legal issues. Lots of judges don't like being seen as the bad guy in front of the victim's family. Lots of things that can take place. So when you go up on appeal, the only thing that matters is what's on that dry, cold record. Talk about taking the emotions out of it. When you simply review a transcript for objections, was this sufficient evidence? How does it read on the paper, right? They'll still get the exhibits. The appellate Judges will get the exhibits, but they look at it in the sense of, was there something, legal error that was made that resulted in an unfair trial? The appellant in that particular case, which will be Chauvin, will file his brief, and then the Attorney General's office usually defends those briefs, and they say everything was fine. No error, no harm, no foul. It wasn't preserved. They're mistaken. It didn't come out that way. And like I said, they rule on legal issues. Did the judge make a mistake? Should he have let something in? Should he have not let something in? And that was so much that it resulted in an unfair trial. Should he have sequestered the jury from the beginning? Should he not have sequestered the jury from the beginning? Those are the issues that the appellate people will decide, and we'll go from there. Debbie M., which charge takes precedence? Well, the second-degree murder is by far the most serious charge. So if the court were to sentence him on that charge, the second and third degree are usually lesser included offenses. So those would all merge, and they would sentence him on the second-degree murder charge, the most serious charge in this particular case. Because the second degree, you have first-degree murder after deliberation. You have second-degree murder. Then you have, reckless manslaughter, criminally negligent homicide. Well, those are all necessarily lesser included offenses of first-degree murder. If you're found guilty of the more serious one, you're really found guilty of everything right below that as well under the eyes of the law. So the third-degree murder and second-degree manslaughter should really merge for sentencing purposes, and the maximum penalty, should be that 40 years. Or if the court were to say, no, I'm going to sentence you separately, they would probably run concurrent, since it's the same acts that brought him there. So Shelley, I think the answer would be concurrent, because it's all really the same factual situation. Lynette, are all judges elected? It depends. Each state, I'm not going to say that I know how they do it in Minnesota, so I don't know for sure how judges are selected in that particular way. Let's see here. Yeah. I mean, a lot of people have a lot of questions. Well, what about this particular fact? The jury gave it the weight that they believed that it deserved, and like I said, they've decided that whatever fact or facts that were highlighted by the defense that were brought out, that they didn't carry the day. And so that's it. And like I said, the jury has spoken. We all should respect the decision of the jury. And I'm sure Mr. Nelson will even say at sentencing, we respect the jury, but it doesn't mean we're not going to appeal. We understand how they could reach their decision. And he's going to probably say that they, the pressure that they were under, etc. But the process is, okay, the jury has ruled. The next step is the defense then goes and does the appeal. Maybe they get some relief. Maybe they don't. Probably to put it in perspective, was it 98% of the cases, maybe 95% of all cases result in some sort of plea resolution of a case. If it goes to trial and you lose, and you go up on appeal, the last number I saw is that you have about a 2% chance of getting your case reversed and going back and getting a new trial. 2%, not exactly great odds. And that's why people oftentimes take plea dispositions, is because the unknown creates fear and anxiety. At least the known, people can deal with it and get along, so to speak. So, when clients say, well, I'm going to take it up on appeal, and I'll take my chances on appeal because we lost that particular issue. And you have to tell a client, you got maybe about 2% chance, man. 2%, not great. So, you can pick your poison, so to speak. But, yeah, that's Scott. This is Claire. If comments are critical of the channel, the mods remove the comments. Just wanting a little clarity. Well, Claire, if you're critical of the channel, feel free. You can email me, Scott@ScottReisch, REISCH.com, and you can tell me what complaints you have of it. I don't get into the nitty-gritty of people removing things. Obviously, I give the mods a lot of discretion as to what they feel is appropriate. They are volunteers. They don't get paid. I think we maybe sent them some gear or something at one point, right, Frank? So they do it because they like and appreciate our channel. We appreciate them. I don't know what it is. I mean, hey, I got thick skin. I can take it. But just come tell it to me directly. If you got a problem with me or my channel, like I said, here's my email, Scott@ScottReisch.com. All right? Hopefully that answers the question. Ellie, couldn't be a jury in a high-profile case, too much big decision. No matter the outcome, I hope they get the respect they need from the public. No one should criticize the jury in this particular case. They made the decision based upon the evidence in the courtroom that they had, and they followed the law. Okay? No one should be criticizing the jury. They have spoken. Like I said, you can respect the jury decision and yet still go off and appeal because that's saying the judge made an error. But this judge was pretty good. And, there may be a couple of issues, but I don't know if it's coming back on appeal. I don't know. I don't necessarily think so. Let's see here. Yeah, I have no problem with our mods. And listen, I appreciate the mods. And if somebody's critical of me, that's okay. I have thick skin. I really do. I get it. Not everyone's going to like what we have to say. Heck, I get accused of being too tough on both sides of cases. I mean, it's crazy. No matter what I say, somebody doesn't like it. And if both sides get upset with me, they don't like the analysis, then I must be doing something right because I'm just telling it the way it is. There's any reasonable doubt nor the jurors. Just me. Since Scott kept telling us he didn't have time to watch the trial, but kept saying there was reasonable doubt. Actually, I did watch the trial, and then I caught up because I was in trial all last week. I caught up over the weekend. And I think the defense did a good job with what they had to work with. And a reasonable juror could have found that there was reasonable doubt. They didn't, though. So that's the way it is. And I'm telling you, maybe I'm just, like I said, I've said this before, I got in trouble. I've been accused that I have a heart, but that I keep it, right next to my, my bed at night in a jar of formaldehyde. Maybe I just look at things a little too objectively sometimes. Maybe that's what's trained to do. Remove the attorneys are trained. They're trained to take and remove the emotion from the battle, right? Why do you hire attorneys? Somebody to step aside, take the emotion out of it so that people can make good, clear decisions, right? Usually when the emotions go up, the poor decision making also increases, right? That's why you hire an attorney, because they're supposed to be removed from the emotion of the battle and say, here's good fact, bad fact. You need to consider both these facts when making your decision, client. And that's the way I look at it. I mean, I'm sitting there thinking, yeah, you could say there's reasonable doubt there. You got multiple people, doctors that are saying that he didn't die of asphyxia. He died of a heart attack. Bottom line, if jurors were convinced of that, they could have said that and they could have walked out and held their head high. They didn't buy it. They weren't buying what the defense was selling. So hopefully that answers your question, just me. And yeah, I did watch it the entire first week. And what I couldn't watch because I was in trial last week, I crammed it in over the weekend. So yes, I did. I'd say I'd watched 95% of the trial. See, and that's the thing. Somebody wants to criticize me or the channel, put it right there. I'm okay with it. I can defend what I have to say because I don't think I'm going out on such a limb on anything whatsoever in my analysis. I try to keep it to the facts and to the law. Attorneys are trained in the law, not compassion. A little side anecdote here, and then we'll let you all go. But I had a trial this past week, and the prosecutor was basically saying, "Oh, it's so sad, it's so sad, it's so sad." And my position was, look at the jury instructions. Nowhere does it say that emotion comes in anywhere when judging the credibility of a witness on the stand. It's their strength of memory. And 2 times people have told me in life, nobody cares about your feeling. One, when I went to the Marine Corps. The second was law school. Nobody cares what people are feeling. It's about the facts and the law. That's why we have it. It's facts, law, remove the emotion. Why? Because then supposedly it's supposed to be fair. So let's see here. It will be decided there's not enough evidence for a retrial, no evidence for the case because nothing outweighs the verdict. Well, some things do. If there was errors that were made, then the verdict can be set aside. But like I said, there's about a 2% chance of a case coming back on appeal. Let's see here. People have freedom to watch or not watch complaints on Scott. Yeah. It is what it is. People don't like it. I literally have people that will send me an email saying, "I can't believe I agree with you on this particular case. How dare you?" And then they'll say, "I can't believe I disagree. You're wrong on this particular case." Well, okay, that's fine. Nobody says to watch my channel, you have to agree with me on everything. The purpose of the channel is hopefully to educate people on the process. And here, if you were able to watch the entire 3 weeks, which, I'm not saying everybody does, but you can go watch the entire process on video here and watch it. So before you criticize the decision, everybody that wants to do that should watch the entire trial. Let's see, Scott, your mods are the best. Thank you. I big shout out to all our mods. Appreciate everything they do. Tough job. You're never going to keep everybody happy. Let's see. Expecting massive resignations from the PDs all over the place. I don't think so. I've heard stories where a lot of people, the police forces, they don't feel welcome. They're leaving, and they should do that. I've always been a firm believer. If you don't like your job, go find a new one. Go find a job in somewhere else that you want to do. So if people resign from the police department, that's their prerogative to do so. Who wants people that aren't happy, particularly in law enforcement, not doing a good job? Their job is to serve and protect, right? Let's see here. Who is the one who is on the picture? That is Lieutenant General Chesty Puller, probably one of the greatest Marines ever. Didn't take crap from anybody. So yeah, anyone know if you can wash? All right. Well, there you have it. We brought it to you live. The jury has found Derek Chauvin guilty of second-degree murder, third-degree murder, and second-degree manslaughter. Derek Chauvin was taken immediately into custody as his bond was revoked. A pre-sentence investigation was ordered, and sentencing will be in roughly 8 weeks. And it should be televised as well. And Derek Chauvin should probably get set for at least the next couple of decades in custody. So that's all we have for you tonight, or at least right now. We'll be live at 6 p.m. Mountain Time on our live show, both here and on Facebook, and our Patreon shortly thereafter, where people can call in as well. So thanks for watching. Hopefully you enjoyed our breaking news coverage of the verdict in the Derek Chauvin matter regarding the death of George Floyd. Have a wonderful day. We'll see you later tonight at 6 p.m. Mountain Time.